Rumors are swirling about what is going on in the Kyle Rittenhouse jury deliberations. One such rumor is that the defense believes the jury is currently split 6-6, which means the jury will be hung, there will be a mistrial, and then there will be a retrial. This may be why the defense has filed a motion or a verbal motion for a mistrial. What we saw from the defense early was a request, a motion for a mistrial with prejudice, which most of you know means the case is over, it's a mistrial, and Kyle Rittenhouse cannot be charged again for the same crimes. But the defense then came out and said, we'll take a mistrial. Stands to reason they believe the jury is hung, and it's likely going in this direction anyway. Now, some argue that a mistrial for Rittenhouse would be good because now they know the state's entire case, and it has exposed the state's cheating, which will advantage the defense in having a retrial. I think it's fair to say the judge should rule on the motion for a mistrial with prejudice immediately. He should grant this motion. Kyle Rittenhouse should be free to go. I don't know if that's going to happen, but the other rumor is that there is a single jury holdout, a Karen, as it were, who feels entitled and says, no, I want to go through the evidence. Well, according to memos that were given by this juror to the judge, it appears this individual has a perspective based on the prosecution's view of what happened, because there's way they framed things. So notably, the defense says that Kyle Rittenhouse, dropped a fire extinguisher. The prosecution says he put it down. And a memo says, please prepare the video of Kyle Rittenhouse putting down the fire extinguisher, which stands to reason they believe the prosecution's version of events. Now, it's minor. We don't know exactly what's going to happen, but the defense is willing to take a retrial straight up. But I don't think that's what should happen because we have new information. The identity of the mysterious jump kick man has been revealed. And apparently, the name of this witness and this individual who attacked Kyle Rittenhouse has been known to the prosecutors and was withheld from the defense. We are beyond constitutional violations, my friends. I mean, it has been stacking up. And if the judge doesn't rule mistrial with prejudice, I believe our justice system is done. You look at some of these stories, man. You look at the torture going on for the January 6th defendants. And it's funny because we talk to people on IRL and they say, you guys realize that the federal prison system has always been this way. And I'm like, you don't got to tell me. I've been against private prisons and I've been against, for the most part, our entire prison system since I was a teenager. There are a lot of conservatives who believe if you don't commit a crime, you'll be fine. And then we end up with a bunch of innocent people getting raided by the feds. You end up with Kyle Rittenhouse. You end up with people being tortured in these jails. And, what's funny is the left won't come to defend them, even though they've typically been the prison reform people. I'm absolutely all about prison reform. Let's go through the list before we tell this story. The prosecution committed a grave constitutional violation against Kyle Rittenhouse by questioning his Fifth Amendment right to remain silent in front of the jury. The judge snapped, "How dare you?" That alone, he said, "You're over the line." The prosecution attempted to admit into evidence, with the jury present, evidence the judge had ruled inadmissible. The prosecution provided the wrong video to the defense. There is a high-resolution drone video with a strange format, and they gave the defense a low-resolution version, crippling the defense's ability to craft an argument around the provocation narrative. The prosecution claims high-resolution video shows that Kyle Rittenhouse raised his gun and pointed it in the direction of the Zeminskis. The defense, given a grainy video, couldn't see anything and probably just assumed this video is too grainy to make that argument anyway, so we're not going to need to say much to the jury other than this video can't be seen. But then the prosecution says, we have an enhanced version. And the defense argued that's CGI. That's right. The prosecution then got admitted into evidence CGI, computer-generated imagery, which never should have been allowed. But they took advantage of the fact that the judge didn't understand this, and the defense wasn't smart enough to explain to the judge a very simple point. Your Honor, the video and footage that they claim is enhanced is not video or photo of the night in question. It's video and photo generated by a computer a couple of weeks ago. And then if he says, well, bring in an expert, I'd say to the expert, when was this file generated? And the expert would say 2 weeks ago in my lab. So this file was not created on August 25th, 2020. No, it was not. Your Honor, this is not video from the night in question. That got admitted. That gave the state the ability to get the provocation instruction. Well, Now we're on to the next grave constitutional violation, the withholding of evidence. Maurice Freeland, jump kick man. Throughout the trial, they were referring to him as jump kick man because they didn't know who he was. According to Fox News, get this, Freeland approached the prosecution to testify in exchange for immunity for other charges, including a DOI, but they rejected the offer, according to a source familiar with the discussion. This is crazy. Tucker Carlson has a longer opinion piece on this, and he says, so that means that Rittenhouse's defense attorneys never got to cross-examine this man or introduce any evidence about his behavior that night. That's not a small thing. According to the Daily Mail new reporting today, the man's name is Maurice Freeland. Freeland has admitted that he attacked Rittenhouse moments before another man, Anthony Huber, started hitting him in the head with a skateboard. Now, what you guys need to understand about Anthony Huber is that he ran up. I could be wrong. I'm pretty sure he ran up and hit Kyle with the skateboard. Kyle keeps running. He deflects it. Someone goes up and hits him in the back of the head. He eventually falls down. Anthony Huber then comes back and hits him with the skateboard again, trying to grab the gun. Check this out. Tucker Carlson says, that means the state knew all along who Maurice Freeland was, but they withheld that information from Kyle Rittenhouse's lawyers. And as a result of that, Kyle Rittenhouse was deprived of his constitutional right under the Confrontation Clause to challenge the accuser in open court. That's not supposed to happen. It can't happen. And that's not the only relative evidence that was withheld from Kyle Rittenhouse's lawyers during the trial. He says, we aired some drone footage on the night of August 31st, 2020. At the time, we were interviewing a lawyer called John Pierce, who was then representing Kyle Rittenhouse. The drone footage that aired on the show has become part of the Rittenhouse case. Prosecutors claim that footage shows Kyle Rittenhouse raising his rifle in a provocative manner at an accused arsonist called Joshua Ziminski. The footage doesn't exactly show that if you look at it carefully, but that's what they're claiming anyway. The prosecution's theory of this case is that Rosenbaum began chasing Kyle Rittenhouse after Rittenhouse pointed his rifle at Ziminski's. Conveniently for the state, however, Ziminski, like Maurice Freeland, never testified in this case. Why? Because prosecutors made sure he couldn't. Prosecutors charged Ziminski with arson and then delayed his trial so he would not be available to testify at the Rittenhouse trial. By the way, this is relevant too. Authorities say Ziminski brought a gun to the right and fired a shot before Rittenhouse ever pulled his own trigger. How's that for relevant? But jurors never got to hear Joshua Ziminski explain that. Tucker says the drone footage we aired on this show was never provided to Rittenhouse's defense team. Instead, they got a blurrier, low-grade copy of the tape, and it was cropped. One is a high-quality image, one is low quality. There's no comparison between the two. The defense had no way to analyze the high-quality footage during trial and provide it to their video experts. They couldn't verify the footage is accurate or make any arguments about what it shows. They just had to accept the prosecution's version. Now the defense only realized this after one of the prosecutors admitted out loud, apparently by accident, he admitted that his version of the drone footage was, quote, much clearer than the footage the defense had. The Ziminskis, I believe Joshua Ziminski, that was his name, right? He's running behind Rittenhouse and Rosenbaum, and he fires his gun into the air. That's criminal. You can't do that. He's being criminally charged. It would have been great if he could testify as to whether or not Kyle Rittenhouse pointed his gun, if Rittenhouse pointed his rifle at Ziminski. Ziminski could testify. But as the defense accurately pointed out, they don't control Fifth Amendment rights. The state does. Isn't that amazing? A prosecutor can come to you and say, we want you to testify. And you'll say, I plead the Fifth. And he'll say, we grant you immunity in all charges stemming from this case. And they'll hand you the form and they'll sign it. Now you are compelled to testify because you can't incriminate yourself. The defense can't do that. So with the Ziminskis, the prosecution in their closing argument said, well, we can't get them to testify because they have a Fifth Amendment right to remain silent. And the point in question is the judge was basically saying, I don't see the Ziminskis as complaining witnesses. They didn't come in here and say he pointed a weapon at us. That would be a crime. And they said, well, they have a right to remain silent. And the defense said, Your Honor, no, they don't. They do only as it pertains to us going to testify, but the state could grant them immunity and get that testimony. Instead, charged him with arson, delayed the trial. Much like, I believe they did that to not Gage Grosskreutz. Gage Grosskreutz has his charges dismissed. The corruption here is palpable. And the prosecutor knew who Maurice Freeland was, offered to testify in exchange for immunity, and they didn't give the information to the defense, so the defense was unable to investigate who this guy was, what he was doing. Maybe there's something here. Maybe he should testify. Maybe they could subpoena him and watch him plead the fifth. But they knew who one of the attackers was. But they once again either withheld, manipulated evidence, just put it plainly, committed a grave constitutional violation against Kyle Rittenhouse. The judge must declare a mistrial with prejudice. Now, let's talk about what may be happening anyway. First and foremost, the judge said there would be a day of reckoning on this drone footage. I think it's a strong possibility that today the judge declares a mistrial with prejudice. He may just declare a mistrial. It's the easy out. Let's see if this judge has a spine. He might. He might not. If it were me, I had declared a mistrial with prejudice already. Now, I'm not a judge. I'm not a lawyer. And maybe that's an irrational, impassioned, I refuse to stick, But when I look at all of the things that have been done by the prosecution, the grave constitutional violations, the words of the judge himself, I would not tolerate any of this. I would say to the prosecutors, you have defiled this court. You have spat in the face of all that we hold valuable and true in our legal system. You have besmirched the good name of this court. Get out. Mistrial with prejudice granted. But the judge says this is the jury's trial. Your Honor, how could it be the jury's trial when evidence was withheld, manipulated, and when they've questioned the Fifth Amendment rights of the defendant on the stand? The jury is probably confused at this point. Which brings me to, has jury foreperson gone rogue and is holding back acquittal? The judge may, and this is what he said, he's going to wait for a verdict. Because if a not guilty verdict comes in, then the motions are moot. And that may be good news for the defense. If they do come back and say not guilty, he'll be like, you don't need a mistrial, you don't need a retrial, it's done, goodbye, have a nice day. And it absolves him of any responsibility. But will the judge have a spine? Because if the jury is being hung up by maybe a 6-6 split, if it's being held up by the fact that there are protesters outside, the very same people, and what I mean by people is not individuals, the group, the ideology, the movement, the very same movement that burned down your city. And wait till you see my later segment today about, I'll just tell you, the New York Times withholding, covering up the story, people being brutalized in the street. Those people are outside. The jury knows it. And then they're being told to cross them. The judge says, well, we've blacked out the bus so that they don't see one side or the other. No one fears a right-wing mob coming out and attacking jurors. It's the right that wants the system to work, and they want to uphold the values and make sure that the businesses don't burn to the ground. It's the left that wants to destroy all of our institutions. From the ashes of the old, we will build anew. So the jurors know it's not the right. They fear the left. The judge should have declared it already. But maybe he still will. Here's what's going on. We have this from Andrew Branca, probably the best legal analysis on self-defense, especially as it pertains to this case, considering not only is he very knowledgeable, but he's an expert on self-defense, and this is a self-defense case. What better analysis? He writes, has jury foreperson gone rogue in holding back acquittal? Now, he goes on to mention MSNBC. We all know MSNBC's been banned from the building from trying to expose the jurors. Mistrial with prejudice, please. Juror requests to take jury instructions home. Well, this is weird. When the jury was brought into the courtroom for purposes of dismissal, shortly after 4 p.m. Wisconsin time, Judge Schroeder imprudently asked if any of them had any questions. One did. A woman juror asked if she could be permitted to take home a copy of the 36 or so pages of jury instructions. The judge looked over at the parties, and although the state appeared to make no particular signal, defense attorney Mark Richards shook his head slightly, but observably in the negative. Despite this, Judge Schroeder announced that he would agree to the request and that the same option would be extended to all of the jurors. Whether only one juror who made the request ultimately took home the instructions or whether multiple or even all jurors did so is unknown. Frankly, it's rather remarkable that any juror who had already been struggling with the instructions for more than 7 hours today alone, as well as the 2 prior days, would be interested in continuing to work with that at home in the evenings. Frankly, I think it was a bad call both for Judge Schroeder to agree to this request, as well as to do so in the manner he did. First of all, if he wants all the jurors to return to deliberations fresh and rested tomorrow morning, the last thing he should want is any jurors continuing to work on these instructions alone in the night. Second, allowing the jurors to take the instructions home encourages what lawyers call the dictionary game. This occurs when the jurors start to do their own research into what various terms and instructions might mean, including looking up words in the dictionary. The trouble with encouraging such behavior by the jurors is that the word, like say provocation, has a specific narrow legal meaning, the context of the jury instructions that differ from the general broader common use meaning one might find in the dictionary. Jurors are not supposed to make use of outside resources to inform their arriving at a verdict, but permitting them to take the jury instructions home encourages exactly that. And furthermore, prejudice, malice, they mean very different things in the legal sense. So people often say, this is really interesting, when it comes to defamation, they say you have to prove actual malice against a public figure. And what the layman believes, that means you have to prove the person was acting maliciously and they were out to get you. What it actually means is that specifically, I believe, they knew they were lying. Not that they had any ill will towards you, but that they knew they were lying. And prejudice. It's really funny to look on Twitter and people say that they've made a motion for a mistrial with prejudice. And people think prejudice means like bigotry towards, a person for some specific characteristic or belief. Like a mistrial because there was prejudice. And then they'll have the trial again. It's like, no, that means they can't retry this. That's fascinating. People don't know the legal terms. Neither do I. I learned this stuff from like reading legal analysis. I am no lawyer, but at least I know a little bit about that and can tell you very simply what Andrew Branca says. Legal definitions, not the same as regular definitions. He goes on to say, third, the judge addressed this question from the juror in front of lawyers and looked to them for a response. That means Mark Richards shaking his head, indicating he preferred the jurors not to be given the instructions despite the request, could be observed by the jurors. Richards appearing to prefer the denial of a juror's request could be perceived negatively by that juror and others, creating a bias against the defense. The judge should instead have either discussed the request with lawyers while the jury was removed from the courtroom, or more conveniently, held an impromptu, whispered bench conference with the jury present but outside the range of hearing. Next, I have my suspicion of what, or rather who, is holding up the verdict in this case. That is, juror 54, foreperson, is the holdout. He says, I have a growing suspicion that this jury has not yet arrived at a unanimous verdict of acquittal only because of the resistance of juror 54, a woman who also happens to be the foreperson who seems to be the holdout against acquittal. The jury selection risk to Kyle was always going to be a mask Karen type, usually a leftist political persuasion, bossy, entitled, and status sensitive. This is very, very speculative, and I don't necessarily agree with this. I do agree with the analysis that this is a prosecution biased individual who is refusing to allow this to go to acquittal. He says, there has been one apparently female juror who on several occasions can be overheard being unusually familiar with Judge Schroeder. Not in the sense of knowing him personally, but in the sense of engaging in a relaxed discussion that one does not usually find between a juror and trial judge. Then we have the jury note from yesterday asking for access to Exhibit 5 of the drone footage and related evidence. It was written by Juror 54, the foreperson and an apparent woman. The note says, please prepare Mr. Rosenbaum shooting event 1. And then it says FBI aerial with all, I can't read that. POIO, what does that say? I don't know. Marked drone video, zoomed in image still after Mr. Rittenhouse put down fire extinguisher, full event video, regular slow motion. We will request when ready. The tone of that note suggests to me that the person who wrote it is accustomed to giving orders to underlings, personal assistants, staff, household help. And here the note is being addressed in this tone to the trial judge, as if the judge were a staffer to the jury foreperson. Then, this evening, we had the very unusual request to be permitted to take jury instructions home made by a single juror, a female juror. I suspect that all of this conduct is that of Juror 54, the female foreperson of this jury, who I suspect is precisely the kind of mask Karen, left-leaning, bossy, entitled, and status-sensitive juror who would be most likely to hold out against acquittal. Finally, my friend Jack Posobiec was kind enough to remind me that during jury selection, I made a particular note of Juror 54 at the time, as I was live commenting right here at Legal Insurrection. 54 knows some of the witnesses named, but could set that aside. I've also heard from sources in a position to know that when polling was done around jury selection, prospective jurors who knew any participants in the August 2020 riots, which would likely include some of the witnesses, tended to trend 75% against acquittal. That's all a guess, but one informed by some experience with both juries and masked Karen types. Here's the video in question. So that means to say, during jury selection, Branca noted that this individual may be biased, and they're going to allow it anyway. This person now appears to be the foreperson, maybe, not entirely sure. But it stands to reason an activist got on the jury and is holding it up. Will the judge have the spine to say, you've made a mockery of my trial, of my courtroom, to the prosecution? Or will he be ever so spineless? I don't know. I actually like Judge Schroeder. He seems like a good dude. He really does. And the media's been very unfair to him, smearing him, lying about him. But he may just come out to be someone who goes, you know, look, we had a juror who was like, I can't be on the jury because I believe in the Second Amendment right to keep and bear arms. Amazing. This is why conservatives lose. That's not bias. The Constitution says you have a right to keep and bear arms. That is not bias. That's exactly who should be on the jury. Someone who recognizes our rights under the Constitution. What are you going to do? I can't be on the jury because I believe that the defendant has a Fifth Amendment right to remain silent. Well, people did. You can't question that. That's amazing what people will say. Will the judge be the type to say, I have seen enough and you have besmirched this courtroom? Or will he be like that guy and say, look, it's not for me to decide. The jury said so. And, you know, we know that there was grave constitutional violations. The defendant, he can appeal. Have fun in prison while you're figuring it out. Because that's what will happen. You know what the problem we have in this country is? A lack of a spine. If I were the judge, if I was the judge in any one of these cases, Chauvin or this one, and I believed that there was a grave constitutional violation, like he has already said. You think I'm scared of these extremists, these ideologues? You think I'm scared of being canceled? Never. Never gonna happen. Now, I'll tread carefully, and that's where I respect the judge. Because far be it from me, I try to keep things family-friendly on IRL. I try to make sure we take more serious discussions that threaten the risk of getting banned to our members-only segment, because the idea is we want to market and show people, hear the conversations, but you can't have it in front. The speakeasy's in back. So I can absolutely respect that the judge won't be as brazen as I'm saying right now. And, you know, by all means, I'm worthy of criticism in that capacity. So I can respect the judge saying, we'll wait for the jury. But there is a line for me and for everybody else. There are certain conversations that they have to happen in the public. They have to happen on YouTube, regardless of what YouTube thinks. Because if it's the truth, it's the truth. And there are certain lines that I'm not willing to cross. But there also is reasonable tact. And that is, if I can keep this up and running, this show, I can tell you to go to timcast.com for the members-only segments where you're going to get more unfiltered conversations. Rest assured, our opinions don't change. It's just certain subject matter, and we swear a whole lot. But that being said, the way I described it, if Google came to me they emailed me and said, we're now requiring all of our, YouTubers to send in their proof of vaccination, otherwise they'll be banned, I'd be banned. Because there's a line. There's tact, and then there's a line. I would not give in to something that absolutely violates my principles. As I often describe it, and again, far from perfect by all means, you can criticize this. If I have 100 things to say, I won't sacrifice 99 for one. I'll make sure that one thing that needs to be said can happen in a place where people can be told that's where it is. 99 is still very valuable for everybody. If the judge's attitude here is, I can't just make a mistrial with prejudice because they'd burn the city down and it would create major conflict, I need the jury to come to a conclusion on their own, and hopefully it's the right one. But if it were me, to be reasonable, I would absolutely have mistrial with prejudice right there, ready and waiting. Maybe it's a little bit tough guy, hyperbole for me to be like, I'd say immediately I'd bang the gavel, and the reality is I'd probably be very much like this Judge Schroeder. It very much would be. Maybe I'd be a little bit more brazen because you can tell I get a little bit more hot-headed than he is. He seems to be a good judge. But I will say this. If we do not get a mistrial with prejudice, we're in trouble. We really, really are. And if this foreperson comes back and convinces them to finally just say, whatever, guilty, I don't care, then we are all irrevocably damaged. I certainly hope that doesn't happen. We'll see as the day progresses. Stick around. Next segment's coming up at 1 p.m. on this channel. You're not going to want to miss my later segment. I've already got this big story. It's about, for those that are listening on the podcast, you've heard this, but James O'Keefe, what the FBI did with the New York Times, the New York Times is defying a court order and a cover-up of the riots by the New York Times. Serious, dark stuff. I will see you all at 1 p.m. Thanks for hanging out.